Hi everyone, how are we all doing? I trust that we are doing well. I can see that Professor Samuel is with us. You're welcome, sir. I can see Onye Chuku. Thank you for joining us earlier. I saw you earlier. Damilola, Paul, Solomon, Faith, Oluwafemi. Thank you all for joining us early. So you're all welcome to JIIPCC Internship and Mentorship Program, and this is for intellectual property. Today we'll be talking about intellectual property and technology, and I'll just go straight to read what we're about. I know that most of us know it already, but it's good that we hear it. Okay, maybe I'll skip that for now. So we'll just go straight into the presentations for today. My name is Juliana Imam. I would like us to also know that there is a provision for the mentorship, private mentorship for those who might be interested. So you can take advantage of it by using this link on the screen. Okay, so let's hear from our presenters for today. Who is presenting for group one?
Hello, I'll be presenting for group one.
Okay. Okay, please go ahead. You have 9 minutes.
Okay, diving in, our topic for today is IP and technology. Basically, particularly looking at IP in blockchain with particular focus on smart contracts and NFTs. That's a relationship of the blockchain technology and IP as relates to smart contracts and NFTs. So basically, the blockchain is a system of recording information. Oh, okay, sorry. Let me share my screen. Okay, so basically, the blockchain is a system of recording information in a way that makes it difficult or impossible to change. That is, you cannot cheat the system. The way the blockchain works, it records information in blocks. So once a block is a field of another block of information comes in, and this information is not just hosted on one server. It is hosted on different servers on different systems. So if you tamper with one block of information, when the system does its check, it will see that, oh, this has been tampered with, when it more or less confirms with the other blocks containing the same information on the system. So basically, the blockchain serves as a foolproof or a near foolproof means of storing and recording information. And it is decentralized, and it is deemed as transparent. So quickly moving on, how does blockchain technology, how does it improve, how does it enable intellectual property? So given the unique characteristics of the blockchain, given the unique characteristics of the blockchain technology, it can be used as an evidence, or it can be used to determine, to record or to track ownership, authorship, and the origin of intellectual property rights. So let's say we have an information. Let's say, oh, okay, we want to encode an information that, okay, someone created this book, someone wrote this book, we have that information on the blockchain. It cannot be changed. And then if the owner of that book is transferring rights as regards to the book, is licensing rights as regards to the book, such information will be contained on the blockchain. It doesn't change. And then the blockchain also can also serve as an IP registry for works of for intellectual property works. As it is currently, a lot of registries regarding IP, trademark, patents, and co. There is this, how will I put it, there's this inefficiency with them as regards tracing the origin of works. A good example would be music clearing. Let's say someone samples a piece of music and then is looking to clear that sample. It is usually unnecessarily hard to clear samples because you have to first identify who actually owns the copyrights in that piece of music. So and to do that, you have to identify who wrote the music. That's the lyrics, the music, and then who record. So you have to applying blockchain in this instance helps us keep a permanent record, keep a traceable record of the ownership of these moving parts of intellectual property. It allows one to be able to trace the origin and ownership of IP. So quickly moving on, as regards to blockchain, IP, and smart contracts. Smart contracts are basically a set of codes, a set of information, a set of rules, programmed, written, that are self-executing. So if you say, if this person pays, this is would automatically transfer rights to him. That can be encoded on the blockchain via smart contracts. So as soon as the conditions encoded in that code are met, the contract executes, itself executes. There are a number of uses for smart contracts on the as relates to IP, but I would explain this more when explaining the NFT aspect of our work. So quickly moving on. NFTs basically are non-fungible tokens. They are non-fungible in the sense that they cannot be exchanged for something identical or something of equal value, and they are created by minting them on the blockchain. NFTs are usually minted on the Ethereum marketplace. So as regards NFT, anything can be an NFT. You can literally mint anything. As long as it is an asset, as long as it is data, you can mint it. So the major issues regarding NFTs and IP on the blockchain are issues of ownership, issues of possession, issues of copyrights. So quickly moving on, as regards issues of ownership, I'll look to use a case study of Jack's tweet. That's Jack, the founder of Twitter. So Jack minted his first ever tweet, and then he sold it as an NFT. Now, the platform that hosted and more or less facilitated that transaction wrote it in the smart contract that facilitated that transaction, that what that person owned was just a certificate that said, oh, you have a copy of this tweet. They did not own the copyright to the tweet itself, meaning they could not print the tweet and probably print it on a shirt and sell the shirt or something. What they had was just bragging rights that, oh, I own this. And basically that is what an NFT is, more or less a means of authentication, a sign of authentication. So I think I'll use an illustration of limited works. So let's say an artist creates an artwork, and then it creates 5 copies, limited edition copies, numbered copies, and signs them. Now, those numbers and the signature of the artist are more or less to authenticate that these artworks are part of a series. This artwork is an original copy, or is an original copy, or is a copy of the original. So that's more, but it is not the original itself. So what that person owns is a physical copy of the artwork. They don't own the underlying rights to the artwork, and that is more or less what NFT is. You own the, will I say, bragging rights to the NFT, but you don't own the underlying assets. That's the let's say original painting now, or the digital assets to the NFT. So these are issues that have been how do I put it? Yeah. So then there's also another case study. There's a case study of CryptoKitties. These guys, so they made collectible cards, and then they sold them to people. And in the smart contracts selling the cards, they put in a clause that, okay, people can reproduce, commercialize, or use these cards as long as they do not earn more than $100,000 a year from their exploitation of those cards. Then we also have the NBA Top Stop, which sells NFTs of plays, movements in their contracts. They specifically stated that you cannot commercialize this NFT. What you just own is the right to display that, oh, I own the NFT to this moment of NBA history. So leveraging on the blockchain more or less, okay, another issue regarding IP, NFT, and blockchain is that of possession. So when you create NFT, usually you do not add the, will I say, underlying assets. Given ownership is not being transferred. But in the event ownership is being transferred, you also have to encode into the smart contract that underlying assets. You have to encode a link saying, okay, this is where your artwork is posted. It will be more or less posted forever here, and you have access to it. Once you click on the link, once you take access, no one else can access that NFT, and you have all the ownership rights to it. So these are issues, and they are more or less encoded in the smart contracts. Licensing is another use of NFTs, blockchain, and smart contracts. So in the event someone has an artwork, someone has a piece of intellectual property they want to license, they can mint that right, and then through their smart contract, determine or dictate the terms upon which that right would be license. So when all the conditions of more or less exploiting that right has been met, it would automatically be executed, and it will be encoded and recorded on the blockchain. So nobody can come in future and say, oh no, you did not give me this right. Oh no, I did not exploit this right. And another use of the blockchain, NFT and co, is that it can help an artist keep track of their royalties. So like I said, once you enter into your contract, I mean, it's a code, it is a computer code. So you can say, okay, I have my music hosted on Deezer, on Apple Music, on Spotify. So immediately you get up to 100 streams, it more or less automatically deducts money from your host. It deducts the money and pays it into your specified bank account. You don't need any human interaction. You don't need any back and forth. As long as certain predetermined rules, certain predetermined conditions have been met, the contract executes itself. So we've had issues of people minting. Yes, we've had issues of people minting work of others, like this tokenized tweets case study. They went on Twitter, they took people's artworks and then they minted them and were selling them. So when the owners of these artworks discovered, they reported the account and they got their works taken down. So which leads me to the issue of enforcement. How can you enforce your IPR? How can you protect your IPR on the blockchain? Well, I think, or I believe you can do a marketplace watch, something similar to a trademark watch, whereby you keep an eye on the NFT marketplace to see that your work is not being put on sale by someone that doesn't have the right to do it. Then you can also send, or you can also issue takedown notices when you find out your work has been minted without your authorization. And then the blockchain also can be used to track resale rights. So in the case of artworks, where you sell an artwork, subsequent sales of that artwork still generate royalties to the original owner or to the original creator. So using a blockchain or minting that rights on the blockchain, keep tracks of subsequent sales of that NFT, subsequent sales of that right, and automatically pays the relevant royalties to the creator of the work. So basically, there's a lot to talk about. There's a lot to cover in relation to this topic, but given our time frame, I mean, time would not allow us to go too much into this. So basically, as a concluding point, I'll just say we should look into adopting the blockchain as a means of managing IP rights. I believe the blockchain has a lot of potential as for use as a registry, as a store of record. There's no record room at the CBN bonds or this thing, record room at the trademark registry bond. No, everything is out in the open. You can see, oh, someone has already registered this trademark, and as such, I cannot register it. You can see, oh, someone is attempting to register a mark I already own. So you can easily keep track of the ownership, of the use, and of the licenses given to this right, or coming out, or being or being assigned from these rights. So yeah, the intersection of IP, blockchain, NFTs, and smart contracts have a whole lot of potential, I believe, should be further explored. Thank you.
Thank you. Thank you very much, Femi. Thank you for talking about this passionately and also for shedding a lot of light on the topic. Thank you so much. So let's move over to group 2. Who is presenting for group 2? Okay. If the person presenting for group 2 is not around, let's move to group 3.
Hello, good evening, everyone.
Good evening.
My name is JIIPCC and I'm presenting for group 3. Please just hold on. Let me share my screen. Sir, I need to know if you can hear me.
Yes, we can hear you. Please proceed.
Okay. So for group 3, we'll be talking about intellectual property and data protection and privacy. From previous sessions, we understand that intellectual property generally refers to creations of the mind, while IP rights are the rights that are enjoyed by individuals to be able to own and benefit from the work that they create. Intellectual property protection manifests in form of copyrights, patents, industrial designs, trademark, among others. So delving into today's topic, data protection, data privacy, and intellectual property. Data protection is the legal framework which offers protection to the personal data and information of individuals. In Nigeria, the Nigerian Data Protection Regulation, NDPR, is regulation that offers protection to personal data and information of individuals. Let's make it simple. The terms data privacy and data protection, they are often wrongly used interchangeably. As much as they go together, they're actually different. Now, data privacy defines who has access to data. Sometimes when we're filling forms online or making applications, we enter our details and then they ask us to read the privacy terms and conditions. Most times, I'm sure we don't go through it, but if you go through it, you know who your data is going to be shown to, what they're going to use your data for, who's going to have access to your data, if they're going to be sharing it to third parties, or to the extent to which your data is going to be used. So it's contained under data privacy terms. While data protection provides tools and policies that actually restricts the access to data. So most times when we find these privacy terms and conditions, the data privacy and protection terms are contained in a single document, whether we fill forms online or maybe offline, maybe a printed document. So companies are expected to take measures to protect private user data, and compliance regulations ensure that user privacy requests are carried out by these companies. So when you consent to their privacy terms and conditions, sometimes you can't go on without consenting. So at the point where you consent, it means you allow them to use your data for whatever they have stated in their terms and conditions. That's why you need to read it. Data protection plays a vital role in business operations by preventing data breaches, damage to reputation. Data protection solutions often rely on technology such as encryption, endpoint protection, firewalls, among others, to be able to protect user data or data that is compiled. Now, today, many people consider data as the new oil, because you can imagine what people can do with your data. They have your information, so they can do a lot of things. So companies can use your data to create new marketing strategies. They can use it for commercial exploitation. This is why we're discussing data in today's IP class. Under this topic, okay, basically, the topic of today is where intellectual property intertwines with data protection and data privacy. Under it, we'll consider different headings. We'll consider AI innovations, we'll consider database, right? We'll consider algorithms, and then we'll finally answer who owns data. So artificial intelligence innovations that use biometrics data are on the rise. While the intellectual property potential for such innovation is vast, issues can arise with the use of biometrics data in view of newly enacted and developing data privacy laws and regulations. Biometrics data relate to physical characteristics of the human body or the behavioral traits of human beings, while biometrics refers to the automated recognition of individuals based on their biological and behavioral characteristics. Sometimes some of us use phones, like maybe the iPhone, maybe some Android phones, take note of your biometrics, the biometric data. They ask for your fingerprint, they ask for your eye scan, they ask for face scan to be able to lock your phone or to do to carry out transactions. I know I use fingerprint to make some payments. So they take your information, and this information needs to be protected. The AI innovations, the technologies that are used, they can be subject to patent. So we can find patent manifesting itself there. Now, let's move to database rights. Now, this database rights is a sui generis right, which means a right that is unique. It's of its own kind. Now, it seems to be like an extension to copyright because it's not exactly recognized in some jurisdictions, but in jurisdictions like the UK, the database right is actually recognized. Now, it serves as an extension to copyright. Some economies are granting protection to original databases in order to capitalize the database industry. The database right is a sui generis property right that is quite different from copyright. It exists to recognize the investment that is made in compiling a database, even when it does not involve the creative aspect that is reflected in copyright. So the database right is considered an extension to copyright. So in some jurisdictions, you can find justification for the database right under their Copyright Act. For example, under the Nigerian Copyright Act, we find that, sorry, let me get my source. We find that where, I think that's section 1, that as far as what you're trying to copyright is fixed in a medium, then you can copyright it. So database is like a compilation of data, and then you have prepared it in your own way and created your own database. So as much as you did not create the data, but the mere fact that you compiled it in your own way, it can be subject to copyright. In some economies like India, the copyright is broadening to accommodate the inclusion of protection of databases. Although in the US, databases are considered a collection of facts. And because facts cannot be protected by IP, so they think that databases cannot be protected. In UK, database rights last for 15 years from the date of creation or from the date of publication. To make learning easier, let's consider what database is and the content of a database. A database is simply information that is set up for easy access, management, and updating. It can contain data records of customer data, sales transaction, financials, and even product information. They collect information on people, places, or things. A database can be used to improve business process, keep track of customers, secure personal health information, or just to store personal data. Now, many times when we fill the form, we're asked to consent to their privacy terms and conditions. It enables the user use the data as contained in the terms. A database could be in text form, numeric, or even pictorial representation. The components of a database include the hardware. The hardware of a database, that's whatever they use to store it. It can be the computer, the servers, the hard drives. Now, those things can be patented because the hardware, their technologies, they can be patented. Now, it also consists of the software or the applications that give users control of the database. It can be subject to copyright. We know that softwares can be subject to copyright. So it consists of the data itself, which is the raw information that is collected. Since fact itself cannot just be copyrighted, a compilation of facts, which is the database, can actually be copyrighted under the database sui generis rights. Then we have the data access or the language. That's the programming language that is used to impute the data. If it is unique, if it's a unique code or a unique programming language, it can also be subject to copyright. Then we have the procedures for entering the data, for creating the database. So most times when customers connect to servers, the owners of the servers lose some set of permission or control over the servers. So we have access to a lot of things on Google, on this one. And so the owners can create encryptions, firewalls to just prevent people from accessing the data. So these procedures have to be encrypted, because basically you cannot just, there are only a few ways to do some things. So you cannot exactly just copyright one way and say, okay, only you are the one that's going to be using it. So instead, it's better to just encrypt those procedures so that people don't have easy access to those ones when they are using your service. Then we move on to, okay, yeah, I found my section. So under this section 1, sub 2, paragraph B of the Nigerian Copyright Act, it provides that a literary work shall not be eligible for copyright unless the work has been fixed to the definite medium of expression, now known or later to be developed, from which it can be perceived, reproduced, or otherwise communicated, either directly or with the aid of any machine or device. So a database can be created, a database can be stored, it can be reproduced, it can be communicated. So we can find justification for copyrighting a database under that section. In the US also, the justification can come from section 1/101 of the US Act that provides for compilations of existing data. In the interpretation section, you find compilation where, as far as you have collected in group, then you can store and copyright. So because we cannot copyright data because it's mere fact, but when we compile it, then we can protect it. In summary, under the UK copyright law, a person only infringes a database right if they extract or utilize all of the content of the database. So if my database contains everyone in this group and their phone numbers and emails, if I just speak out Madam Juliana and copy and paste somewhere, I've not infringed on it. But then if I just take the whole information, if it was saved and like protected, then I've infringed on a person's database rights. Now we move on to algorithms, which is what we'll be talking about. So algorithms refer to sets of instructions that are used for solving a problem or accomplishing a task. So people, I don't know the set of people that create algorithms, but they're mostly used by computers as a set of rules to be followed in calculations or other problem-solving situations. Now, from research, algorithms can be considered as a trade secret to prevent them from being stolen. So you can protect your algorithms as trade secrets so that no other person uses your algorithms. Now, people can also formulate different algorithms and compile them and create a software. That software is subject to copyright. So the software can be copyrighted. So we're seeing where IP manifests under data protection. Now we'll just move to the last part of who owns data. Now, many questions are, okay, so who owns the data that I'm entering online? Is it the person I'm sending to, the form I'm filling, the owners of the form, or is it me? Now, legally, GDPR, which is the General Data Protection Regulation, it was created by the European Union, and it's supposed to be a regulation for every member of the European Union, or anybody who collects data that is related to any member of the European Union. Now, Nigeria is not a member of the EU, but as far as you collect data from that concerns anything about the EU, then you are also subject to the GDPR. Now, the GDPR stated that the only legal owner of data, the only legal owner of data is the data subject. Now, data subject is the person from whom or about whom you're collecting the data. So if I enter my details in a form, I am the data subject. So the GDPR says that I am the only legal owner of my personal data. Now, under the Nigerian Data Protection Regulation, a data controller is a person who either alone or jointly with others determines the purpose for or manner in which personal data is processed or reproduced. Now, so when I'm filling the form, the people I'm filling the form to are the data controllers. So they actually, there's a fiduciary relationship existing between the data owners, which is me, and the people I'm filling the form with, the data controllers. They owe me a duty of care. So the duty of care to protect whatever data enter into their system or into their form or into their database so that it is not breached. Sometime in 2018, Uber Technologies, they faced a settlement issue with the US Federal Trade Agency because they were alleged, there was an allegation that they did not protect users' data enough, and so about 22 million names and phone numbers and emails were just leaked out, and so data was breached. So data controllers have a duty to protect the personal information of the data owners. Once your consent has been given, when you enter into your details and click OK, you've agreed to the terms and conditions. I think even before this Zoom meeting began, there's this pop-up that will come on. This meeting is being recorded, and so if you read it, you see that okay, if you say got it, it means you're consenting to be recorded. So, or if you don't want to be recorded, it will ask you to leave the meeting. That's the only way. So you give your consent for all these things. So you cannot later say, why did my face show on this thing? I didn't want it. It means you've given your consent for your data to be recorded. So I like to say, however, that data is just fact, and therefore it's not exactly classified as intellectual property. Now it's the way that you process those facts, like creating them in a database, that is when it can be protected. In summary, privacy rights are not intellectual property rights. Although some people argue that people's privacy should be given, people's personal information should be like a property to them. So, because if you just say that, okay, your own personal data is intellectual property, it defeats the whole purpose of IP economic goals. So how can I say, okay, I patented my name, Onyeka? What am I going to, or I've copyrighted my name. So your own personal information is not exactly your intellectual property, but there's argument that people should at least own moral rights to their own personal data. Now, whether as drafters of data privacy and protection terms and laws, we should remember that they ought to be in compliance with the data protection regulation. Thank you very much. And that will be the end. Thank you.
Thank you very much. Thank you so much. I enjoyed your passion and fire for the subject matter. Thank you. And I'm enjoying what's going on in the chat room. We have professors there and we have other people that are making us smile. Thank you. So let's move to either group 2 or group 4. Group 2 or group 4? Who is presenting for group 2? Who is presenting for group 4? Okay, so we can stop sharing the screen now so that the next group can start. Group 2 or group 4?
Hello, good evening.
Good evening.
All right, so Samuel presenting for group 4. Sorry for joining in quite late. So just give me a minute to share my screen.
Okay. So you have 9 minutes. I hope you're able to keep to that. Let's see.
Sure, I will. Okay. Good evening, everyone. So, hope you can see the screen. All right.
Yes.
Okay, good evening, everyone. So today our presentation basically lies with IP and AI technologies and robotics. So we also try to like break down this presentation to make it quite understandable, so it's not a bit too complex. So first off, we're going to give like an historical background to what AI is. And we know that AI is just an acronym for artificial intelligence, right? And artificial intelligence is the ability for machines to perform certain tasks, which needs the intelligence showcased by normal human beings. And it's just interesting because from the field of AI research, and over time how technology has developed, is that human beings are able to come up with mechanisms or algorithms or written codes that allow certain computer machines or computer softwares to evolve. So I think I'll just give a practical example. If you've seen this movie called Free Guy, it talks about a particular algorithm, a particular character in a data set, like in a virtual world, that evolves. It was a particular code that evolved and became self-aware of its existence. So basically, that's how artificial intelligence works. A typical example of how artificial intelligence works could be let's say, your cars now, for example. When your cars have some sort of overheating problem, the mechanism tells it to do certain things. So for example, you could tell the car to shut down and then engage the cooling system. That's AI. Or if your battery is low for your phone, it could communicate to the source code to lock your phone and save your battery, and all of that. Or even when, what's the word? If the microwave system, for example, when it gets to certain degrees, the sensor trips up and tells the microwave to stop. So yeah, and artificial intelligence is not just, tied down to just software and all of that, but also everything that we see around us. So let me just quickly run through the slides so I don't take much time. So in 1997, yeah, we honored that the reigning world chess championship and Grandmaster Garry Kasparov was defeated by IBM's Deep Blue, which was a chess playing program. So I don't know how many people play virtual games here too, but for example, as well, when you play FIFA, it's a virtual game. When you play FIFA for a while, there's a way the setting works such that if you're playing at the easy stage and you're beating the computer tends to automatically switch to a more difficult stage to make the game interesting for you. So these are those ways in which artificial intelligence basically, helps our relationship with computer work very fast and very well. And the characteristics of AI is that first off, they have the capacity, to learn through experience and interaction. So like we said, artificial intelligence evolves over time. It basically evolves and it collects information from its environment. It basically interprets information and acts on those things. So that's why we have your question of people being scared about AI taking over the world and people being scared about the fact that AI should be granted IP rights. So going further down, we also have to ask ourselves the question, whether or not to grant AI, IP rights. So in the presentation, we're looking at two things. So first off is the fact that we understand that people that create, manufacturers, inventors that create AIs and robotics, they have certain IP rights vested in them because they are legal personalities. But the question remains as to what extent do we qualify AI as a personality? So we know that intellectual property derives its fundamental precepts from the basic rights to property, which Mr. Poja, explained last week. So we look at the right to own property. Article 27 clearly states that everyone has the right to freely participate in cultural life and enjoyment of community. For example, in the Constitution, we have the right to movable properties and non-movable properties and all of that. So that also brings us to the question of what a legal personality is. So in the course of our discussion, we understood one thing is that you have the artificial and the natural person. So the natural persons are we human beings, we can move around and do stuff. Then the artificial personality applies to companies, corporations, and basically these are the only set of personalities that we believe, aside from human beings, have the capacity to enjoy certain rights to IP, certain rights, to own IP rights and all of that. And then when people acquire legal personhood from when they were born, judicial persons do so when they're incorporated. So for example, if a company wants to buy something, it purchases, let's say, a share or purchases a technology, acquires technology, what you have is the company acting in its own corporate entity, right? And unlike human beings, whereby I can go to a store and then purchase something in my name, or I can go to a store and then enter into contracts in my name. So currently, we're dealing now with IP rights and AI. So AI is currently experiencing a paradigm shift from theory to commercial application, and key players in the AI sphere are acquiring large portfolios of IP rights. According to WIPO's report, about 340,000 patent families related to artificial intelligence have been published from 1960 up until early 2018. And then we understand that IBM has the largest portfolio of AI patents with 8,290 patent applications, followed by Microsoft with 5,930 patent applications. Get so basically, if you come up with an AI program, if you come up with an AI system or AI software, it's no doubt that the creator, the inventor of that AI enjoys the patent rights to the AI, because no AI basically what's the word now, comes up with a system or a model at which it does something. So we understand that patent rights is granted when one, you come up with a new or a novel way of doing something, and secondly, that way of doing something is not particularly what's the word? It is not particularly known to those in that certain industry. So I'll give you another example. For example, we have the Twitter algorithm here. So the way the algorithm works now is quite different from the way the algorithm at what's the word, Instagram works. So for AI, if you build up an AI machinery, for example, now the IBM Deep Blue, IBM obviously enjoys patent right over the AI. But now we're going to the deeper question as to how far can we grant AI rights? So can AI acquire legal personality or not? If you've read the books by Dan Brown, Deception, I think Deception Point or something, it was talking about the fact that AI came over and killed its owner. And so right now there are basically a lot of questions as to whether or not you can grant AI IP rights, because you need to ascertain the facts as to whether or not they actually have legal personality or artificial personality. So in the US states case of Taylor and Ashland, and in the United Kingdom, we had the case of Stephen F. Taylor and the Comptroller General of Patents. The patent application of the same patent family were rejected due to the naming of Dabo's AI system as inventor. Yeah, so I think for this, we basically are gonna go on two grounds here. So some factions of my group, if I use the word factions of my group, believe that AI should not be granted legal personality because, first off, they do not have the basic concern of consciousness. So and the argument is this: for example, for an artificial company, when the company does something wrong, you can always lift off the veil. So lifting off the veil is where you go behind the company and look into who the board of directors are, who are those taking the actions, and you can hold them responsible. Yeah? But for AI, if an AI goes about shooting people or killing people, who takes responsibility? So those are the questions that we have to ask ourselves. I know. So there are three ways now we're going to just answer the questions whether you can grant AI, if AI should be granted legal personality. So the first one is no, because we believe AI does not have the ingredient of consciousness which the human being has. So there's no moral compass as to the actions of AI. Yes, they can come up with different things, but by the time we start granting AI patent rights to build and develop stuff, then we could as well just grant them legal personality to keep on not going on with the actions. Now, the other factions are saying yes, but not totally yes. Yes, to the extent at which AI does good. But for these, we're relying on the Bentham theory. So the Bentham theory basically states that the law, so that the law should basically focus on following the utilitarian, what's the word, theory, which states that the law should be developed in such a way that it's good for the people. And what we understand now is that, of course, granting AI legal personality rests solely on the laws that are available in certain countries. And we pose that if the law follows the Bentham theory about the law being used for good, then why not grant AI legal personality subject to their creators? So what we basically propose is, instead of saying you're not giving AI any rights, just as you have children that are less than 13, they go into contracts based on their necessities. So why not give AI the right to own some things, but it will be subject to their creators? So AI and the inventors basically share a joint responsibility. You get, so for example, if I create an AI here and the AI brings up something new, myself and the AI will be given joint ownership or joint ownership. We'll be given joint ownership over the patent on the new mechanism that the AI brings to bear. So, but of course, the major concern still holds like who is responsible. So we believe that with this, when the laws are made and policies are drafted, with this, we're able to curb the question as to who takes responsibility for the actions of the AI, especially when they go wrong. And so current protections offered by IP to AI, of course, we have the patent, basically covers every new model of operation, every new means of application of technology. Then we have copyright. So of course, as humans, when you're writing the source code, copyright basically covers all of that. And even, these AIs, you can incorporate voice systems into them. For example, you have Siri, yeah? Siri is also a basic example of AI. And then the person that voices Siri, now that's your copyright over the voice, over sound recordings. So that also applies. AIs don't really have much of, what's it called? User interface, but we could also use industrial design. So I'll have to make allusion again. For example, if you are a fan of Star Wars, you'll see a lot of machines that are being depicted and they have certain shapes that they take. So it's possible that AI also works with that. And I think last year, during the COVID time, China was developing these sort of robotic machines that would dispense sanitizers, at the airport stations and all of that. So yeah, these are examples in which you can actually enjoy protection over your AI development. And this also applies to robotics. So whatever machine you're building, the patent works on that. You have the copyright, on the software codes. You could have the copyright also on the voice, sound recording depictions that they give, and all of that, and also the industrial designs. Yep. So in summary, the team basically is just saying one thing, is that yes, engineers do enjoy copyright protection, they do enjoy IP protection, patent rights over every AI system they build and over every robotics or engineering system they build. And also we'll further say that AIs and their inventors should be granted joint patent rights. So that way the inventors are liable for all the actions of the AI and also the benefits that comes with it. So thank you.
Okay, thank you very much, Samuel. So AI and all those things you're talking about, it's not like an easy topic to talk about. For you to talk about it, you have to be intelligent. So, and you seem very relaxed talking about it. That means it's something that you can talk about for another hour. So thank you so much, Samuel. Well done. So let's hear from group 2. Group 2. Who is presenting for group 2? I can see fine people putting their videos on. Thank you. Group 2. Who is presenting for group 2? Okay, so it's like group 2 does not want to present today. So we'll just go straight to our mentors for today. Our mentors will comment on the presentations, and after they've all commented, then we would answer questions. So we have 4 mentors for today. We have Mr. Folarin Aluko. He has been with us since the first quarter since we started. He is from Rockwood Solicitor. We have Professor Samuel Sami Andrews. He's a member of the Faculty of College of Law, Prince Mohammed bin Ford University, AI Koba, the Kingdom of Saudi Arabia. We have Akin Agumbede. He's from Tech Hive Advisory, and we have Faith Obafemi. She's from Future Proof Intelligence, FINT, and E4E. So we'll be hearing from Professor first, and then we'll hear from Faith, and then we'll hear from Mr. Folarin, and then we'll hear from Akin. Professor, over to you. Thank you so much for joining us.
Yeah, thank you so much. Can you hear me?
Yes, sir.
The connections has been. I'm sorry, I just came in this morning. I was in Nigeria to bury my mom, so I'm kind of a little bit
sorry.
I'm still woozy. So I'm really impressed. I mean, I'm impressed because here we are, my people, and the future dealing with issues that we still don't know a lot about. And chain technology is the new way of intellectual property. And we are kind of, I just had a WIPO event I flew in, that was on the 9th, on this topic. Actually, I was on the panel on this topic. Oluwafemi also. I'm going to send you a lot of literature because you kind of have, I don't know whether you've read an article by, I don't think it was open source, whether you read an article by Dr. Andres Gudamas, was published in the Journal of International Law late last year on the non-fungible tokens. He is one of the authorities to unravel what we have to do, or how should we look at technology, especially its non-fungible tokens. Smart contracts is a very difficult topic. I was one of the first people that started working on it like a long time ago. You have to read more on it because the problem is that is smart contracts enforceable? If we look at the traditional definitions of contracts, before smart contract, we have what we call wrap contract. And until recently, we're dealing with whether a wrap contract, I'll tell you what wrap contract is, but let me just tell you a story. Wrap contract opened the doors, and fortunately, not at the highest level, the circuits in the United States courts operate. The circuits have recognized wrap contract. That means wrap contract, I'm going to use examples. Wrap contract is what you do every week. When I'm going to use what you're familiar with, Netflix. When you sign with Netflix, there's a lot of terms of use or terms of service. You have to do certain things, either you click, either you browse before they allow you to go in. And at times, you don't see those agreements. At times, you're so much in a hurry. You accept. And the courts in the US have now, as there's adequate notice, and there are a lot of rules, and the jurisprudence is kind of clear on wrap contracts. Because although the Supreme Court has not decided on it yet, I think things are going up from the circuits and until we get there. Sorry, NEPA. And so you're gonna read about wrap contract first. I read about it. I published, I think OAU, one of my journal, my article in OAU is on my, it's free on my academia.com. And you can also read about it. You did a good job there. And it's a good concept that you have a hold on. But what I want you to look at very well, you made some good points. Ownership, distribution, those are all issues that these technologies have raised. But the problem still comes to the basics. What is the regime in Nigeria as we are today? Because I'm actively on this, I'm doing research on them. I don't see any law in Nigeria right now that supports these new technologies. Yeah, we can look, stretch like lawyers, we can as scholars into other laws, and someone raised a very good law, the data protection, the consumer rights laws and all that. But IP is a specialized area. If you don't have a law that deals with IP, the more waters are going to be muddied. And the judiciary in Nigeria, I'm not trying to run anybody down, I've written about it, it's not new. They still don't really grab very few judges. Recently, 3 months ago, a judge ruled that because someone did not, a high court judge, federal high court, because someone did not register copyright, then there's no copyright. That is the problem. That's wrong jurisprudence. Yes, the Nigerian Copyright Commission is also muddying the waters with their new policy of trying to have a database for people to register their copyright. That is not the law. We've wrote them, we've said it. A policy player should not muddy the waters for us. The US registers copyright not because of ownership status, it's because of litigation. And the US is very sophisticated, you know? It's because of damages. You have to register your copyright so that we know your damages. But here in Nigeria, they are muddying it. I was involved in the current review of the copyright laws in Nigeria, and we raised this issue. I still raised it in my last paper, published journal, that came out in December. So the problem, I'm so glad, honestly, you people are really on top of it right now, and Nigeria is in safe hands. I've listened to everybody here. But where would you start from is the laws. See, if you're living in with my world, you live in America or you live outside, you know, in Europe, you can enforce it because the laws are there. But there are no laws. The dudes in the National Assembly are busy doing something different. So how do you students and young scholars mobilize the policy? See, I'm a policy, my IP is all about policy, because that's where we can change lives. IP is the richest space now to make the poorest of the poor rich. We have overtaken oil and gas, extractive industry, so we have to take this to the level that it's going to be tangible for you and I, for our families. Because IP now, the poor guy in Aba, in Calabar, can become a billionaire without going to NMPC to look for work. You don't need them. You need this. And when you have this, and you have a specialized lawyer who can protect this globally, you are up there. So if you even look at all the industries now in Nigeria, the young man there who brought this money thing, what's the name of the company, who changes money and all that. Sorry?
Slaughterwave, Paystack.
Yeah.
Patricia.
That's IP. All this, the content creators in YouTube, Nigeria is doing very well. So look at that. Look at what you're going to do with the laws in Nigeria, because you know we don't have laws. We don't have it. We are just doing filtration, abstraction as lawyers, which is good as scholars. We publish your papers, but we need the policy. Good. So now, I don't know if you are aware of the active case on an NFT. Nike is suing StockX. The cases are already in court. And Hermes, the French fashion house, is suing Rothschild, who is the owner of Meta Buckets. Look at that case, because that's where we are going. You see, even the best scholars right now in IP, we are still struggling to find out. We are the ones, where I say we the scholars, are going to be the ones to tell the Supreme Court when it gets there, because they always come to us for advice. Give us, what's your opinion? Now, it's a little bit, my opinion is that it's a copyright, it's too far to hold NFT and NFT. Even Dr. Andres agrees on that. It's going to be trademarked. It's going to be dilution. You know, because if a lot of you have spoken about originality principles and copyright eligibilities. The traditional jurisprudence of copyright, you all know it, but there is a problem with the originality aspect of it. Look at the case of Google and Oracle, read that case, please. The current case, Supreme Court, it talks, although it dealt with graphic interface, but it kind of gives us how. Someone said, someone was talking about AI and data. I may not address you again because I'm addressing everything now, because so that I give others time, and because I'm still sleeping right now. Now, who is that? The lady gentleman said something about data is property and data is enforceable. You got to be careful with that, because not all data are protected by IP. You have to use all the theories and analysis of originality, the sweat of the brow, which Nigeria is currently using because of what is in your law, the fierce doctrine, which America, if you've not read it, please, you got to read about those three doctrines of originality, copyright originality. The fierce sweat of the brow was the traditional one, effort. The Nigerian case, it is a high court case where it's Ofrey, O-F-R-E-Y, is the Nigerian case, really explain the sweat of the brow. It's an old case. Read my articles, you'll see it. I actually cited, or John Essien, publication, the current director of Nigerian copyright, is written a lot about that. Read his book. Now, the sweat of the brow effort, which in the case of Okafor's, what do you call it, Okafor's, that between the Omolis case, that they had a problem, but the judge did not really analyze it very well, in my opinion. Law, there was a case like that, Okafor's law, that the judge decided, I disagree with certain things he did there. But be aware of theories that is used to know whether a work, a creation, can be protected by copyright. Data is murky. It's really murky. Not all data. That's the Oracle case has told us that, Google Oracle case. So even if you are using the fierce doctrine, or even if you are using the case of InfoPact, the European Union, the current standard of InfoPact, INFOPAQ, the Court of Justice of the European Union, which is close to fierce, that's, they call it, European Union calls it an intellectual creation, which is close to fierce. All those doctrines, you realize that you have to look at data very well, not all data. A collection of metrics, a collection of things, of people's information embedded in a system, does it fall in line with the copyright originality? So for the lady, gentleman who spoke on that, address your mind to that. So, you also Onyekachukwu that. Now, Onyekachukwu, you have to look at NDPR very well. Is that really, you try to make a distinction between data protection and data privacy. You gave a nice line, I encourage you to write an article on it, because that's a very nice line. You said data is the new oil. Try and write an article on that. Yes, I agree with you. Data is the new oil. But I fall back to my theme. We don't have the laws. So how do you advise the government? You have a good focus. Your talk is a good, but data privacy, what's my business with data? An IP lawyer. What business do I have with data privacy? Do I have any business with data privacy? That's for you to answer if you want to write. Because for me, data privacy is in a different zone entirely. It has nothing to do with IP. So don't mix it up. Good paper. Now again, you said something. You say, sui generis. Is data still sui generis? Because the data has been supported, especially in Western developed countries, with laws. Are they still sui generis? I don't think so. They're still sui generis. Maybe in Nigeria, because we don't have laws to guide us on it. Is data property law or is it IP law? Like I've already answered that question now. So, under our current laws, Onyekachi, how would you categorize data? Could data be protected under any of the theories of copyright, originality? It's murky. So you look at it, expand on it, and see. Now, very good one, Samuel Abu, you talked about IP and AI. My personal opinion, I don't like wasting time on AI and IP because it's a fiat accompli. It's a construction of the Western power. Like I told them last week, why are you still discussing granting folklore protection under IP or under any law? We've been talking in the WIPO subcommittee for the past 30 years. A lot of smart Nigerians are in that committee, but they've refused to recognize my culture, my folklore, until America attacked Louis Vuitton for using the traditional attire of the Maasai people. That's when they started money and started, but they were using our rights and our properties, our cultures, free of charge, just like they use our music. I'm an American, but my parents are Nigerian, so I can talk to them. So that is what I want you, the upcoming, to look at. So much in Africa, there's so much in Nigeria. IP can be used as a point of uniting Nigeria because we are right now in a bad spot. The fishing, Agongo, is a bucket of money. Geographical indication can be Nsuka pepper. It's a bucket of money. Gari, what do you call that sweet gari in Yoruba land? Ijebu gari. It's a bucket of money there. We don't all, it's money, but we have a lot of that. So policy and the jurisprudence must align, and it's your generation. We have failed. So it's your generation to start for the jurisprudence and the regimes to change. We are far, far behind. We are still talking about amending copyright of Nigeria in 2023. In fact, we don't even know where it's going to come out from, where he is now. So I don't want to go into too much politics there, but my practice and my scholarship is policy mostly. So now, South Africa is attempting, and I was laughing, why would South Africa be doing this? Why would they be the ones that start giving AI legal protection, IP protection? Why? Why didn't South Africa find a way to give the herbs that some traditional people there maybe discover to cure HIV? Or their songs? Now, they are caught, attempted, so it's guaranteed that AI will be granted. We are just with the time talking about it. It's going to be, AI will be a human or a legal abstract, a legal personality. It will be. They did it, they changed. Sony, Disney, Sony Bono case, Disney, the owners of the biggest owners of content, they changed virtually, they lobbied the world to change copyright term limit from 50 to 70. And now the whole world is going 70. I think in Nigeria is 70 already, 70 years term limit. It was 50 before. But when Disney saw that their content was going into public domain, they lobbied the world and the world did it for them. So focus, yeah, learn it very well. I like the way you're trying to, Samuel, I like the way you distinguish because that's where it is. That's where it is. The legal abstraction, that's how they can do it. That's how they can, they did it with corporations. They granted corporations legal personality. And it's with the laws. They change the laws. But the problem, like you rightly said, Samuel, is when it comes to liability and damages, when an AI kills somebody, who are you going to hold responsible? Because AI does not have a mind of its own. AI is created by someone. AI, everything about AI, there's somebody behind it. So we're still talking. If you could write a paper on that and let's see, published. So very interesting topic. Thank you, Juliana, for bringing me here. Even though I'm sorry, my voice and all that is still kind of tired. Thank you so much.
Thank you so much, Professor. This is really deep. You've actually turned it upside down, turned it sideways everywhere, and you've given us a very good understanding of all these topics. Thank you so much, sir. So we would move straight to Mr. Folarin. I'm sure he would have a lot of things to respond to.
Hi, Juliana.
Good evening, sir.
Good evening, Dr. Samuel. I don't know how I can follow that to Juliana, but that was, I think you just made my week, Professor Samuel. Thank you very much for that very enlightening intervention. I would say, okay. Thank you very much for having me, Juliana. And well done to all the presenters, fantastic presentation. I think the conversations are extremely topical when talking about, I trust my audio is I'm audible. Juliana. Hello?
Yes, sir.
Okay, great. So the presentations, fantastic stuff. The conversations too, I think are very topical. You can't talk about, we've had conversations about presentations on NFTs, which is the trend of the moment in the IP verse among IP practitioners. And then, of course, we've also had conversations about the representations on AI and the licensing, etc. So I would say, well done to all the presenters, fantastic work. Prof just kind of threw a spanner in the works because he said a lot that one should actually think about. It's unfortunate that in 2022, we're still talking about harmonizing two copyright bills with a view to, and considering that these two copyright bills were drafted, were put together, patched together like a Frankenstein's monster about 10 years ago. And if you think about, if you look at the pace at which technological revolution is occurring on a global scale, you find that we're in terms of regulation, we're a very long way, we're far away, we're far behind, and society is far ahead. Even, I'm not talking about global society that Nigeria, especially the young people, young creators, they have, users have moved with the times, but it would appear as though, speaking now to lawyers and our IP law has not responded adequately or has not been able to catch up with innovation and with society. So we're playing a bad game of catch up. But I think the West, if we wanted to do a comparative comparative look. The West has used copyright to, not just copyright, the West has benefited a lot from intellectual property, especially when you look at you consider the fact that the Western concept of property ownership is individualistic. You would also expect that Africa, which has a more communal approach to ownership generally and of real property and intangible property, would that there will be a lot more in terms of collaboration and development from the user end now, and not necessarily from the policy end. But I think to a very large extent, there is a connection between this dependency on government, which our forebears, I think people from perhaps Prof's generation, this some sort of dependency that they carried, that has been carried over to our generation, if you may. And that's why when you speak with anybody in the tech space, in Nigeria's tech space, for example, and ask, well, what are the challenges? The first thing you hear is government did not do this, or government is not doing that. And that overdependence on government, I think, is the mindset that, oh, it's government, when IP is a private right. And perhaps government's role ends in ensuring that there are policies that help promote the individual's ability to exploit and to innovate, to innovate one and then to exploit that innovation. And everything sits, I think, to a large extent with the government, with the individual rather. Government's role is really limited. I think that's one area where our generation can actually make a huge difference. So I would say, well done to you guys. Well done. Kudos to all the presenters. I think Prof has given me quite a lot to think about. I'll say thank you to you very much. Thank you very much to you, sir. Thanks, Juliana. Well done.
Okay, thank you very much, Mr. Folarin. I also like your angle of discussion. Okay, so let's hear from Faith. Faith Obafemi. Let me just confirm that she's still with us. Obafemi from Future Proof Intelligence and E4E. Okay, the internet connection might be poor, so I don't know. Okay, so while we wait for her, we can move to Akin Aguvede from Tech Hive Advisory. You're welcome, Akin. Faith, can you hear me? Faith Obafemi.
I can hear you.
Okay,
I'm so
okay.
sorry.
Okay. Thank you very much for joining us.
Thank you for inviting me. I actually did learn a lot, even from the presentations, especially those related to robotics. Although I missed most of the early parts for the blockchain case studies. Already, Dr. Samuel has already said most of the things I would have actually liked to say. So what I am going to add is that one should also try to get practical with all of these new technologies. One should try to get practical because as lawyers, we should not only know the law, but we should also be able to understand how this technology itself works. And for blockchain, I'll talk about blockchain because I'm not familiar with AI and robotics. For blockchain, like Doctor was talking about, it would help to even check out smart contract codes, learn how to read them. You don't necessarily need to maybe become a developer or a programmer, but being able to understand how it works is also going to help. And also trying to like use some of the products that are built using blockchain technology. For instance, if someone is talking about non-custodial and custodial wallets, there are different legal issues relating to both of them. But just talking about it in theory might be difficult to understand. So trying to maybe sign up for a custodial wallet, try using it would help you to like understand more how these things work, and that would also help to understand more analyzing the legal issues. So wherever area that one is interested in, trying to get some practical experience about how those things work would definitely go a long way. And as we know, with new technologies, there are always new questions. I know at this time, 2 to 3 years ago, no one was talking about NFTs, but today everyone seems to be talking about NFTs nonstop. And we know that most people assume that once they buy an NFT, they've also gotten the IP rights, and it's taking some efforts, education and enlightenment to let people know that just purchasing the NFT does not automatically grant you the IP rights. So those are the things I just wanted to mention. I know I missed most of the presentation because of the terrible network, but good job to everyone. And I actually did wish I had this kind of opportunity when I was in school. So thank you to organizers and thank you for the opportunity to listen to everyone.
Thank you very much, Faith, for your contribution. I really appreciate even the time that you spent with us, and also for bringing your own perspective to going practical on some of these things. It's ending. Thank you. So let's hear from Akin finally.
Hello,
We
Juliana,
close for today. Yes, I can hear you.
Okay, yeah, thank you. I'm sorry I joined a bit late. Yeah, but I was able to get some presentations before we started, so I studied them before the session. So I would like to maybe respond to some things that I heard from the groups and also one of the mentors said before me. So first of all, from the presentations, they were really, I would say that at least this is my second time with the mentees, and I found the presentations were really well researched. But one thing I want to note here is somebody made mention of some examples of artificial intelligence using movies like Free Guy and Star Wars. And I would like to correct that impression. It is a popular notion to use science fiction, use movies to describe AI, but it can be very misleading, okay? Because what you see in those movies is exaggerated, and in all honesty, it is not real. Isn't that movie Free Guy? I've seen the movie. It is not possible in reality for an algorithm or an AI to evolve like what happened in that movie. What happened in that movie was that if I was to use the technical term to describe what they were trying to describe, they're trying to move from a finite set theory algorithm to Monte Carlo set theory algorithm, which is not. I don't want to go into technicality, but the point is that that kind of thing does not happen. We are trying to achieve that state, but it does not happen yet. It's not yet reality. So that's the danger with using movies to describe AI, because you might end up misleading people. So I know it's not an intentional thing, but it's just that it's something that you should not maybe indulge in a lot. And another thing, I want to just quickly go to something that a mentor said before, one of the mentors that spoke, where he made mention of why probably we should not give so much attention to AI because there are more pressing things like, okay, using IP to protect our folklore and all of that. Now, one thing we need to understand is that AI does not focusing on AI does not mean I will neglect other things. You can do both of them at the same time. You can talk about AI and IP at the same time. Also talk about IP protecting folklore and traditional knowledge and geographical indicators. And in fact, in some parts of the world, they use AI to protect folklore. And I'll give an example. In the USA, they have an issue with protecting the traditions of the Native Americans, their language, their costume, their culture. So what they did there is that they take voice recordings, okay, of the people speaking their language, and they use AI to process it to then create more duplicates of it, so that for future generations, even if that tribe, even that culture goes extinct, or hopefully does not go extinct, but even in the event where that language goes extinct, 60, 80, 100 years from now, as long as the world exists, people can still enjoy those things. So that is AI being used to protect folklore, traditional knowledge. So it does not mean that because we are talking about AI, then we are going to abandon traditional knowledge and all those things. No, they can coexist, and AI can support traditional knowledge and support geographical indicators. So that's one. I don't know, Julian, I don't know if I missed, there was a particular presentation you sent to me that was about open source software. I don't know if I missed if maybe they presented before I joined the session. Hello?
Yes, I can hear you.
So I was saying that there was a particular presentation you sent to me where they were talking about open source software. I don't know if maybe they
okay, yes, that's for group one. Group one, yes, I think they presented before you came.
Okay, yeah. So
one of the groups.
Yes. So I found that presentation quite interesting because it's something that I'm doing a bit of personal research on open source software versus IP protection for artificial intelligence. And the way I see it is that there's, when it comes to open source software for AI, there's like, it's more like a corporate strategy because, okay, yes, usually they will always want to patent their algorithms and inventions. But then again, most corporate bodies, most big tech companies have come to realize that by open sourcing their inventions, they can better attract talent and also use that as a pipeline for increasing their revenue in the long term. So let's say, for instance, like a company like Apple. Apple has a history of being very secretive with whatever they do. But in the past 5-6 years, they've been trying to get a bit more open, doing things like open sourcing their projects, and also there's something I noticed, something they have been doing recently. Allowing their engineers to publish openly, because they realize that, okay, a lot of ML engineers want to be able to publish what they work on at conferences and speak on it. But if you keep everything tightly locked under IP protection, trade secrets, and patents, they can't do that easily. So in order to recruit talent, they need to become more open in that sense. Another thing also, that they realize that, okay, if we make it in open source, we can use it to generate more revenue. So for instance, now, let's say for a company like Google now that has this ML framework, TensorFlow, it's open, okay, anyone can use it. But if you want to build additional projects, you could then use their Google Cloud service, which is paid for. So in that way, open source, making your project using open source software is a way that you can, what's the word now? It's like a marketing channel in a sense. So you use that to then acquire customers who can then eventually start paying for your services. So that's another thing I also wanted to correct, and this is one of the presentations where someone said that IBM has the largest number of AI patents. That is partly correct. IBM has the largest number of neural network patents, okay? But Microsoft has the largest number of ML, machine learning patents. So that's just something that we need to clarify. It's correct, just need to be specific about that distinction. So I think that our presentations are really quite nice, and I commend all the mentees for the work done so far. Thank you.
Thank you very much, Akin. I think that Professor is raising his hand. Maybe he wants to add something before we go.
Yeah, I'll correct the last speaker. Maybe it was not when I started. I'm not saying that AI, the students should not learn AI. Actually, I said that they should study to know it. But you made a very legal, incorrect statement. This is my area of research, and I know it very well. In the United States, listen to me very well, in the United States, AI is not recognized as either owner of any IP rights or has the color of protecting any IP. We are still discussing. In fact, until about 2 weeks ago, the Copyright Office and the Patent Office are still organizing, calling for input by experts to see how we can navigate. Because the law in the US, as it is, Supreme Court law does not even recognize this. But it is correct, maybe you put it incorrectly, that you can use AI to preserve. I think that's where you are going. You can use it to preserve culture. The Native American culture and all that, yeah, you can use AI. We are talking of the IP space. The IP space, it's only about two countries right now that have actually made efforts to make AI, give them a legal color of IP, that's South Africa, I think Australia, and even the EU, which is the biggest market apart from US, is fighting it. So we are not even there, we are not close there. But like I said, this is my opinion. We are wasting time. I said it last week on the 9th, I gave a lecture to JIIPCC. I said that the same thing I'm saying here, we shouldn't be wasting time. My friend, Professor Umar, even added something. I said that we should be more concerned about the human factor. Yes, mine is about building the human, the talent of humanity, especially in the South, the global South, where we've been exploited for too long. So there's a difference between AI used to preserve and AI being a legal person. Sam actually said it very well. He's done a good work on it, Samuel. So that's all I want to impute there.
Thank you very much, sir. I think that we've actually touched everything. There is just one question, however. Let me just read it out. Let me see if I can get it and read it out. Okay. But I think that we can leave the question because we've answered it in a way. But let me check. I'm sorry. Let me just check for the question. Okay. Are there limits to the kind of software applications that can be protected under intellectual property rights? Are there limits to the kind of software applications that can be protected under intellectual property rights? So I think that any of the mentors that is okay to answer this can just go ahead.
Let me take a dive on that a little bit. Yes,
Okay.
Please go and read Google against Oracle. There are so many Google against Oracle. The last case, Scotus, the United States Supreme Court decided, I think it was this year. It's open source. America, they always put it 20 minutes after judgment is already there. So it's a big volume, please. Whoever answered it, read it. I talked about it during the data issue. Yes, the answer is yes, there are limits. Because I'm not a scientist, I'm not a techie, but because of that's digital copyright is where I do a lot of research. There are elements of software and programming that is fair use. And that's what that case decided. Oracle, Google against Oracle. case mostly dealt muchly on programming interface, internet interface. And there are some parts of the software program that is already in the public domain. So you cannot protect, for instance, it could have been copyright, the original copyright could have expired, or meant that it falls under the 4 or 5 criteria of fair use. So the Supreme Court there said, yes, this interface can be protected, and there is a program, it's a software, but this particular one cannot be protected because, and that's why I think Oracle lost that case to Google. So read the case, but of course, when you are dealing with things like that, you have to analyze it from like lawyers do. You have to look at it. Is this software, is it copyright protected first? Meaning it falls under all the criteria of originality. Is it on a tangible surface? Is it original not in the patent sense, novelty, original in the copyright sense? And is it fair use? Because if it's fair use, like if it's something that is already there, or it's something that should not protect, like short names and short phrases and all things like that. So yeah, that is my answer for that. Yeah.
Okay, sir. Thank you very much. So I don't know if there's any other mentor that want to answer this question, or if they're okay with the answer. Okay, so I guess that we're okay with it. I think that we've had a very interesting conversation today. I would like to say a very big thank you to all the mentors, Professor Samuel, Mr. Folarin, Faith, Akin. Thank you so much for joining us, and to all the mentees, thank you for researching. Thank you for working together as a group. Thank you for presenting, for sharing your slides. Thank you very much. I want to wish everyone an amazing weekend, and take care of yourselves. Continue cooperating in your groups so that we can meet next week, Friday. Thank you all. Take care. Bye. Thank you, sir.
Thank you very much.